Court is back on the record and can call up the matter for Christopher Donison, 23 CR 1513. I do have Mr. Donison appearing pro se with his advisory counsel, Mr. Lemus. Mr. Skelton and Mr. Daly appear on behalf of the people along with their advisory witness, Ms. Fick. This matter does come before the court for a continuation of our jury trial. We are outside the presence of the jury. Are there any issues that we need to address before we bring the jury in this morning?
Not at this time. We will have an issue once the people rest, but I think at this point, it just makes sense to call Investigator Fick and do that prior to raising anything additional with the court.
Thank you. Anything on behalf of the defendant?
Nothing. Oh, I have the motion for, to request the witness to testify remotely.
Thank you. And my understand, we can just address this quickly, I think. My understanding is the witness is Mika Villa, is that correct?
Yes, ma'am.
Right when we were recessing yesterday, Mr. Skelton, Mr. Daly, Mr. Donison indicated that Ms. Villa was not able to appear in person, was only able to appear virtually. What is the, I don't know if the people have a position or if they want to think it over first, but I wanted the people to be aware.
We are objecting. I don't know what the basis is contained within the motion yet. I will note there was a previous request. Thank you for Cyrus Haggard and I believe Autumn Haggard to both testify virtually. We allowed that one for Cyrus Haggard because he was in the Department of Corrections and on short notice they weren't able to do this, but we knew that they could only accommodate a virtual writ. My understanding is Ms. Haggard's located somewhere far on the East Coast. Even though she should have been able to be here and the defendant should have coordinated her appearance, the people did not object. Again, trying to give every opportunity to give the defendant the ability to put on his case where possible. Mika Villa is local. She is here. She's in this jurisdiction, and my understanding is she's likely under subpoena. And so she needs to be here in person. They're really absent of extraordinary circumstance. I do not see why she should not be here. I think the reasoning is she has an important medical appointment and she is a registered home caregiver.
I did.
And so,
oh, sorry. I apologize.
I will note she did testify at the last trial. She testified in person. We are scheduled to go 5 days. The defendant will have at least a day and a half to get her to be here and get her to appear in person, and she should be under subpoena. And so this really isn't something she can opt out of. We are requesting that she actually appear in person and be subject to questioning under oath in person so both the jury and the people can both gauge her responses and her demeanor and ask questions appropriately based upon it.
Thank you. And I have not received the motion. I know that Mr. Donison brought it to court.
Yes. Yeah, I'll approach the court with it.
Thank you. I just want a moment to review it to see if the indication is why in here. Thank you.
Okay. Oh. No.
Thank you. I had an opportunity to review the motion. Mr. Donison, any additional record you'd like to make?
No, I'm just that I agree with Mr. Skelton wholeheartedly, and I would prefer that she is here in person, to be honest with you, Your Honor. And if it is permissible, I would prefer that she would be here tomorrow. If he's saying that we have a day and a half, and if we can get her here tomorrow, I would much prefer her be here in person. I agree that a witness being here in person, see their face, their facial expressions and everything, and she is under subpoena. And I would like the court to remind her of that and to compel them to be here by all means. I'm in total agreement with Mr. Skelton on this one. because this witness was here last time, and my heart goes out to her with the child. She was here waiting, and she was here to testify for these 2 days. And I do, and I apologize to her for that. She's not here to hear that. But I'm saying that she was here waiting, and the trial drew out, and we were, she was waiting all these days to testify, but at the same time, she is under subpoena, and this is very important. She's a vital witness, and I want to compel her to testify. I'm not releasing her from it. And if we are waiting, and I anticipate that, that we still have a lot of testifying to do. Ms. Fick, and Ms. Haggard and my grandfather and other witnesses. And if we have to, wait for Ms. Villa tomorrow, then I ask this court to have somebody reach out to her or somebody and to remind Ms. Villa that she is under subpoena and, by order of the court, and to compel her to be here. And she is, and that is an order.
All right. The court has reviewed the motion. The court's denying the request to have her appear virtually. This is a jury trial. This is a jury trial in front of 13 people who give up their time to be here in person. I expect all witnesses to be here in person. I made the allowance similar, frankly, to the record made by Mr. Skelton, is that one witness was out of state and one witness is in the Department of Corrections. The Department of Corrections is not going to bring someone here to testify in person without good cause. Ms. Villa is a resident of Colorado. If she is under subpoena and she fails to appear, the court will issue a warrant for her arrest. But Mr. Donison, it is your job as the person calling her as a witness to secure her appearance here. My understanding is that she's under subpoena. If she fails to appear on that subpoena, I'll issue a warrant. But beyond that, that's beyond the scope of what the court's duties are. Other than issuing that warrant to try to get her here, you can let her know if she doesn't appear that the court will issue a warrant for her arrest.
And she has until tomorrow, correct?
She has until we are completed with this case. I want to make sure that we can get this case to the jury in an appropriate amount of time for them to deliberate. We told this jury that we are set for 5 days.
Yes, ma'am. I will get on
I'm
it.
not going to unreasonably delay this jury.
No, I understand. I
The
understand.
witness who's not going to appear when I issue a warrant. So my understanding, strike that. Again, we've told this jury 5 days. That's what they've all indicated during voir dire, that they were available for these 5 days. If we start getting into next week, there's going to be issues that we have with the jury.
Yes, ma'am.
And so I would try to get her here today.
That's going to be impossible because of the,
I'm not going to hear the excuses of why. If she's not here today, the warrant will be issued for her arrest.
but you,
And you can inform her that the court will be issuing a warrant.
Your Honor,
Try to get her today. At a minimum, she needs to be able to be here by tomorrow morning.
okay, I mean,
But
that's,
if she's not here, I'm going to issue a warrant.
if she's not here by tomorrow morning, there's going to be a warrant?
I would reach out to her and make sure she knows that if she doesn't appear on the subpoena, the court will be issuing a warrant for her arrest.
She can't be, she can't be.
We'll figure it out. I'll work with Zach.
She has, Your Honor, I'm sorry, I know, I don't mean to keep talking. She has just made it very clear because she has a disabled child. And then she cannot be here today at all. That is for sure, That is for sure. And I wholeheartedly apologize. And I am apologizing with my heart. I apologize. And I really am apologizing on that. But she cannot be here today. At the very least, she can be here tomorrow. And I am apologizing for this.
All right.
But she
Then,
cannot be
Mr.
here.
Donison, we're going to address it later because I'm not going to delay us
Okay.
starting.
Okay, I'm sorry.
Have a circular argument with you.
Yes, ma'am.
If she's not here on the subpoena, you can coordinate her appearance with her of when she can appear. But if she doesn't show up on the subpoena, you can let her know that the court will issue a warrant for her arrest.
Yes, ma'am.
Okay, thank you.
And I will call her as soon as I get back, okay?
All right, thank you. Let's bring in the jury unless there's any other issues that we need to address.
Thank you, Your Honor.
Not from us, no.
Yeah. Please rise for the jury.
Thank you. You may be seated. Good morning. Right. Are the people ready to call their next witness?
We are, Your Honor. This time the people call investigator Jennifer Fick.
Morning. Ms. Fick, do you swear and affirm under penalty of law that the information you provide to the court will be the truth and nothing but?
I do.
Thank you. Please be seated when you're seated and comfortable. Please state your full name for the court's record and spell your last name.
Jennifer Fick, F-I-C-K.
Thank you. Mr. Skelton, you may inquire.
Thank you, Your Honor. Good morning, Investigator Fick.
Good morning.
So, Investigator Fick, let me just ask you some background questions about yourself. Are you currently employed with the District Attorney's Office?
Yes, I am.
Is that as an investigator?
Yes, in the Special Victims Unit.
Now, is that role or your job as an investigator with the DA's office, was that your first job in law enforcement?
No, it wasn't. Prior to coming to the DA's office, I worked 17 years with the Weld County Sheriff's Office.
During those 17 years with the Weld County Sheriff's Office, did you have a number of different roles?
I did.
Can you just describe some of the different positions you held within the Weld County Sheriff's Office prior to joining the District Attorney's Office?
Sure. When I began at the Sheriff's Office, I was a corrections officer. I transferred to the courts unit. And then from the courts unit, I became post-certified, which is the standard for patrol. I transferred to the patrol unit where I was an SRO, a school resource officer for 6 years in Meade. And then I transferred to the investigations unit where I did the strike team where we apprehend warrants. We do series of crimes, thefts. I worked in the sex offender unit. And then the last 4 years, I was persons crimes in the investigations unit.
Kind of did almost everything there is to do at the Sheriff's Department, is that
I
fair?
did.
Okay. And then you did your 17 years with the Sheriff's Department, and then you joined the District Attorney's Office. You said you're an investigator with the Special Victims Unit. Is that fair?
That's correct.
Okay. And how long have you been an investigator with the District Attorney's Office?
Just about 5 years.
When did you join the Special Victims Unit as an investigator?
We specialized and made it a special victims unit probably 2 years ago. But since being here, that's pretty much the only cases that I've worked.
And fair to say this is not a case originating from the Special Victims Unit. Is that right?
That's correct.
Okay. Is it also fair to say that sometimes when maybe a victim of a crime is coming in to meet with us or a witness shows up at the front of the office, that sometimes whatever investigator is present may sit in on that meeting? Is that right?
That's correct.
And if you sit in on one of those meetings, potentially you could just become involved in that case going forward.
We do. We like the victims to see our faces, and if you're involved all the way through the process, so they're not jumping around to different people and having to repeat the same thing over and over.
And just kind of turning specifically to this case, is that kind of how you got involved in this case and why you're the main investigator from the District Attorney's Office assigned to this case specifically?
That's correct.
Now, before we go into the specifics of what you did on this case, can you just describe to the jury a little bit about the investigator of the District Attorney's Office?
Sure. At the District Attorney's Office, it's a little bit different at law enforcement agencies. So in law enforcement agencies, a case has already occurred and they begin from the beginning to do the investigation. At the DA's office, ours is a little bit different because the case has already been investigated. There have been probable cause or charges, and the case has been filed with the DA's office. So my role is kind of a handoff where if there's additional follow-up, additional interviews that need to be done, evidence that needs to be collected, I do all of those things.
So if like a question were to arise as the case is pending, potentially you could use follow-up to try to answer that. Is that correct?
Correct.
Or if, and we'll get to this, if a witness comes in for a meeting with a district attorney and they're talking about the case, are you going to be there to help document what is said?
Yeah, we do it as a team. So we usually have our attorney, a victim advocate, and an investigator, because at any time facts could be discussed, and my job is to document those facts to be discovered to the defense.
Because if there are statements that are made, we essentially have to document it and then turn it over.
Correct.
Okay. And so I want to turn specifically to this case. When were you first made aware of this case specifically?
I was made aware on December 18th of 2023 that the victim, Autumn Quinlan, was going to be coming into the office the following day on the 19th, just kind of a meet and greet and answer any questions that she may have.
So she was coming in for a meeting on December 19th of 2023. Is that about, say, 3-ish months or so from September 4th of 2023?
Correct.
Okay. And at that point, who was present for that meeting on September 19th?
It was myself, another DA, Aaron Vargas Gutierrez, and our victim advocate, Amanda DeMint.
So Ms. Vargas Gutierrez is no longer the DA on the case, but Ms. DeMint, the victim advocate, is still.
That's correct.
Okay. And so I guess describe generally for the jury, like when a witness or a victim comes in, that kind of meet and greet, or, we have that first meeting with them. Generally speaking, are we going to go through and ask that person every single question we may have about what had happened to them that resulted in the case being filed?
We don't. Really, the purpose of the first meeting is so they know who the trial team is or who is on the case, and really to answer questions. We do this all the time for a living, and sometimes we use words and things that normal people wouldn't know because they've never been through that process. So it's really just to answer questions, to let them know what the court process looks like, upcoming court events, things like that.
You said you were made aware kind of the day before that you're going to have this meeting with Ms. Quinlan on the 19th. That day before, did you do anything to try to look if there had been contact between the defendant and Ms. Quinlan, I guess, leading up to that meeting?
I did. So prior to meeting with her, I wanted to familiarize myself with the case. So I reviewed the police reports, photos. So I was familiar with the case. And I also did look into the jail system to see if there were any contact between the victim and the defendant prior to meeting with her.
Is it fair to say you observed what appeared to be several hundred calls between the two of them?
Yes.
Okay. Now, on that meeting of December 19th, I think you talked about how oftentimes that first meeting, it is kind of introduction. Here's who we are. Here's kind of some questions about how the case will proceed. At that meeting, did Ms. Quinlan also come in and just provide information about the relationship itself and what had happened both on July 24th and September 4th?
She did. She said she was ready to tell us all of what happened.
And as you, the investigator, did you document in a report kind of detailing what those statements were as you heard them?
Yes, I did.
And so I want to ask you some questions about what Ms. Quinlan shared with you on December 19th of 2023 about those two incidents, specifically July 24th. Did she describe that she was on her stomach with the defendant behind her at that time?
She did.
And that she had been strangled with a sock?
Yes,
Did she describe losing consciousness?
she did.
And then upon waking back up, she realized she had urinated herself.
Correct.
And at that time, did she indicate that Chase was not home for this?
Yes, she did not believe he was home.
Now, during that conversation, did she estimate that the amount of time she was being strangled was approximately 46 seconds?
She did.
Did she sit there and tell you, I know exactly it was 46 seconds and I'm confident and sure about that?
No, we just like to try and get a range because she said it felt like forever, but she just kind of gave an estimate of the 46 seconds.
Now, turning to the statement she made about September 4th of 2023, did she indicate that she went back to the residence, 1600 Fairacre, to get her daughter, Lily?
She did.
Did she also indicate that once she got back inside 1600 Fairacre, she picked up Lily, Lily said, ouch, and then pointed at the defendant?
Yes.
Right? Did she also indicate that the defendant, or that she then asked Lily, what did he do to you?
Yes.
And that the defendant then responded angrily and got upset?
Yes, he did.
And did Autumn, during that conversation you had with her on December 19th, indicate the defendant punched her in the face after that in her bedroom?
Yes.
And that Chase was present for that?
Yes, that he saw that.
Did she describe being knocked to the ground?
Yes, she did.
Did she describe having Lily in her arms during the assault?
Yes, and described their little faces together and seeing stars.
Did she describe that while she was being assaulted, she made a statement to the defendant to the effect of that he hit like a bitch or something like that?
Yes, she did say that to him.
And that in response to that statement, he then threw 3 or more punches?
Correct.
Did she also on December 19th describe kind of a lull or a break in the physical assault?
Yes, where she was able to get up at some point.
Okay. And I think even described sitting on the bed or something like that.
Yes.
While then the defendant was saying things to her. Is that right?
Yes, he was calling her names and berating her.
Does she also describe being threatened with a knife?
Yes.
During that meeting on December 19th of 23, did she also describe that the defendant during that lull got access to her phone and saw she had police contact that day?
Yes, she did.
And that specifically she was telling him that she just got pulled over, but he wasn't believing her.
Correct.
and that had led to the defendant then assaulting her a second time, specifically with a massage gun,
Yes.
and that he was striking her on the feet, the ankles, and the legs with that massage gun.
Yes.
On December 19th, did she also describe that what had stopped the assault was the defendant being told that the police were at the residence?
Yes.
And that once he was told the police were at the residence, his demeanor changed. He grabbed her face and said, "Hey, go hide. Everything's going to be okay."
Yeah. Became very, very calm and grabbed her face and told her it was okay to go hide.
Did she also describe on December 19th that after the defendant said that, she spoke to Chase and Danny and told them to go upstairs?
Yes.
And then she weighed her options of whether to go back downstairs, like when she got to the ground floor, or go out the back.
Correct.
And that she made the decision to go out the back and then fled barefoot a couple blocks over.
Yes, she did.
Now, I want to ask you, you wrote a number of supplemental reports in this case, kind of documenting a lot of the things you did. Before I go into specifics about some of the follow-up you did, is it fair to say you were present for a number of trial prep meetings between Ms. Quinlan and the district attorney's office?
Yes, I was.
And generally, what is a trial prep meeting between like a victim or a witness who's coming in and then members of the district attorney's office?
So as we're preparing for trial, we contact each of our witnesses that we plan to have testify to explain the process, give them kind of a lineup of what day we may need them. And if there are any facts discussed during that, I would document that and turn it over to the defense.
So, hey, here's the expectations, what it's going to look like, where you're going to sit, who's going to be asking you questions, that type of thing.
Correct.
Okay. And then kind of just the procedure, potentially myself will ask questions, then the defendant, then I'll get an opportunity, then maybe the jury, stuff like that.
Correct.
Okay. And then, if there are any specific questions we may have, like you said this, can you clarify this? Or you said that, can you clarify that? That may be a conversation that's had and you would document that. Is that fair?
Correct.
Okay. Generally speaking, during those trial prep conversations, are we going through every single question that's going to be asked at trial and asking them to give a response?
No, we are not. We're just kind of overview of what to expect. We're not asking questions and waiting for a response or anything like that.
So would it be fair to characterize that every single time Ms. Quinlan met with the district attorney's office, she was asked all of the questions I asked her earlier this week, walking her through each of those reported assaults?
No.
Now, during those trial prep meetings, is Ms. Quinlan given all of the evidence in the case?
She is not.
Is she given the statements of other witnesses?
No.
The body-worn camera statements of other witnesses?
No.
What other officers did that she was not aware of?
No, we just want that witness to remember what they remember and not anybody else.
If she asked to view something, is she going to be shown her statements and no one else's?
Yes, her statements only.
Okay. Is she going to be given a list of my questions ahead of time?
No.
And I know we talked about this earlier. You said you document kind of what is said during those meetings to be turned over in discovery to the defendant. Is that right?
Correct.
Is it fair to say that essentially everything we've talked about, body-worn camera of every officer, of every witness, that's going to be turned over to the defendant?
Yes.
All photographs are turned over to the defendant.
Yes.
Essentially every single piece of evidence in the case is turned over to the defendant prior to trial.
Yes, it is.
But Autumn, on the other hand, she's only going to be aware of what she did, what she knows, and what she said.
That's correct.
Now, I want to talk about some of the kind of follow-up you did. Is it fair to say that one of the things you did was you actually drew the connection between the report that was made at the Greeley Police Department around noon on September 4th of 2023 and the later assault that was reported that day?
That's correct.
There were actually two different case numbers of the Greeley Police Department. Is that right?
They are two separate case numbers.
And it took them some time to actually realize that those two things were connected.
That's right.
Did you conduct follow-up and contact Thomas Packard, who was the listed reporting party on the 911 call?
Yes, I did.
Did you actually track down the Greeley Police Department report from March 3rd of 2023, where Autumn had reported calling the police from 1600 Fairacre?
Yes, I did.
Did you track down a protection order that was filed by Autumn on March 3rd and then later withdrawn a week later?
Yes.
Did you get a consent to search form signed by Autumn for her cell phone that was collected by the Greeley Police Department on September 4th of 2023?
Yes, I did.
And then did you provide that to the Greeley Police Department so they could then search that phone?
Yes.
Did you pull those photographs off of Zillow that we've been seeing from inside of 1600 Fairacre that shows the general layout, but some of the furniture being different?
Yes, I did.
Did you also take efforts to get some of the Banner Health records from Autumn's visit to the hospital on September 4th of 2023?
Yes, I did.
Okay, so those are kind of the things we talked about, like you kind of tracking stuff down, filling in gaps, and doing the actual additional investigation.
That's right.
Now, one of the other things you did in this case was that you pulled at times communications the defendant made from the Weld County Jail. Is that right?
Yes, I did.
Now, are you familiar with the kind of operational rules and procedures of the Weld County Jail?
Yes.
Why? Where does that knowledge come from?
Yep. I've worked in the jail, and I still have a good relationship with people that work at the Weld County Sheriff's Office, and we work cases together. So I'm very familiar with the system.
And how long did you work in the Weld County Jail? You worked-
Probably 3.5 years.
Is it also accurate that the district attorney investigators receive training on the jail systems and procedures, specifically as it relates to communications like jail calls and mail and tablets and things like that?
Yes, we do. At the beginning of this case, the jail had a different system, though. It was called the Securus technology. And then in January of 2024, they had transferred over to a different jail communication system, which is called ViaPath. But yes, I've been trained on both of them.
Fair to say you were familiar with Securus because that was the system you used when you worked in the jail, is that right?
That's correct.
And then there was a new system, ViaPath, which you then received additional training on.
Yes, and I do have a user log on that I can actually pull the calls myself.
And so fair to say in this case, I know you talked about how it was initially Securus when it was brought or filed in September of 2023. Now it's ViaPath. Have you accessed communications from the Weld County Jail on both systems in this case?
Yes, I have.
Now, is there any information that, say, someone who's booked into the jail or is in custody in the jail, is there any type of informational packet or booklet they are provided about the rules and procedures of the Weld County Jail, specifically as it relates to those communications and whether or not they're intercepted?
Yes, there's an inmate handbook that all the inmates have to sign that they have knowledge or know where it is. And it has all the rules and regulations and policy within the Weld County Jail that they have to comply with.
And does that handbook indicate that all calls are subject to monitoring?
Yes, they do.
If someone were to make a call from the Weld County Jail, is there an additional identification aside from the handbook that the call they're about to make is also being monitored?
Yes, usually it's posted above the phones when it was the secure system. Now the ViaPath is a tablet system where they can send text messages and make phone calls from the tablet that is assigned to that inmate. So back in the secure system, it's identified above the phone call. It's in the inmate handbook. And then you guys heard in some of the exhibits, it gives the acknowledgement this call is monitored and recorded. If it is intended to be private, like an attorney, then they have to register that phone number to block it so it's private.
So if someone were to have, say, like an attorney calling them, they can say, hey, this is a legal conversation. That's not going to be monitored.
That's correct.
Okay. Same with like mail from the jail. That's legal mail. That's not going to be read.
That's right. Nope. They'll just scan the front of the envelope that says legal, but it's not opened or read.
Okay. But the other communications are subject to monitoring.
That's correct.
And as an investigator, do you also have the ability, if you learn there's potential numbers that are being used to violate protection orders or things like that, to restrict phone numbers inside the Weld County Jail?
Yes. So I can notify the Weld County Jail to block a call if there's a protection order or someone's complaining that they don't want calls from a certain number. They can block them, which means that they're blocked from anybody calling that phone number. Yes.
And so you previously referenced, the jail calls the jury previously listened to, and I think those are People's Exhibits 24 through 27 inclusive. Were you actually the investigator who went and pulled those calls?
Yes, I was.
Okay. Can you kind of describe the process you went through to identify and then pull those calls?
Yeah. So when I access either of the Securus or the ViaPath, I have my own logon, my own password, and I can access them. In order to find calls, you can go to the inmate's first and last name. You can use the phone number that may have been called. You can look up a certain visitor, and all of those calls, depending on how narrow you want it, will pull up with that information.
And so did you specifically go looking for if there were communications between the defendant and Ms. Quinlan about whether the defendant was making statements about Ms. Quinlan not testifying or not showing up for trial based upon what Ms. Quinlan told you?
Yes, I did.
Okay. And so you went looking and those were some of the calls that you had found. Is that fair?
That's correct.
Thank you. Those are my questions.
Thank you. Any cross-examination?
Yes, Your Honor, just one moment. To start off, you mentioned my recorded calls, correct?
Your recorded jail calls? Yes.
Yes, sorry, it wasn't specific on the Ms. Fick. And those calls of mine, you've personally listened to for the purposes of this case, correct?
I can't say that I listened to all of them because you make a lot of phone calls, but I did do intermittent phone calls, yes, and I did review some of them. Not everything that I pulled, I reviewed.
So what determines what calls you listen to and which ones you don't?
Well, I don't have all the time to listen to every call. So usually how I narrow it down is when there's a court hearing, I kind of narrow it down to, because that's usually when people start talking about their cases when they've been to court. So kind of the dates and times that the court hearing in the process of the case.
So in the interim, who listens to the cases for you and tells you when something is useful?
I don't understand your question.
I'm assuming there's an investigator for the jail, correct?
There is, but they're not part of our case. They work within the jail, what happens in the jail. But they're not part of my case. They're not investigating and listening to calls. If it's a safety and security issue, they may give me a heads up. Hey, I don't know who's assigned to this case. I have some information.
You're familiar with Richard Meredith, the investigator for the jail, correct?
Yes, I've worked with him.
And he has been giving you information on my case, correct?
As it's concerning, he will. Not everything that happens in the jail he tells me about, but if there's mail or something that is a safety and security issue, he knows that I'm part of this case, so he will reach out to me.
And he has mentioned my phone calls too, correct?
Which phone calls?
Any of my phone calls that he felt concerned about?
I don't know if there are phone calls. I know he did reach out earlier this year about some tablet messages that you had sent.
And so, all right, give me 1 second, please. So you were aware that early on, back when Ms. Quinlan and I were speaking on the phone, you were aware that Ms. Quinlan was putting phone time on for me, correct?
I don't know who put the phone time on, but you were communicating with each other.
You were listening to the phone calls though, correct?
Yes, but I didn't look to see who put money on the account or anything like that.
So it's your testimony today that you didn't hear her say that she was the one loading the phone time on for me?
I mean, in the exhibit, she talks about putting it on your grandpa's phone, so it would make sense that she probably was putting some phone time on.
But you're testifying that she was the one saying that she was loading the time on, correct?
To which account?
To any of the many numbers that she set up for me to call.
Sure.
Okay. And is your testimony today that she had at any time she had the option to block my phone calls, correct?
Yes, and in there it does say if you would like to block this number, that you could do that as well.
And she did not.
She did not. She just advised me that she didn't like the continued
But that
communication, so she asked me to block it, and I said that I
But
would.
that
do
was much later. That was later. Just yes.
I believe it was the first time that I had met her, December 19th. And that's when I blocked her number from the system, was that same day that I met with her on December 19th of 2023.
And this is after she set up about 7, 8, 9 numbers, correct?
I don't know how many numbers. There were multiple numbers. I don't know if there were that many numbers that she used.
And this is after I had told her I wanted to probably end the relationship again, after we went back and forth, and you heard in the conversations, correct?
Yeah, I mean, we argued back and forth.
We
a
went
lot.
back and forth quite a bit, correct?
Yes,
And between fixing it and not fixing it, right?
right.
Yeah. You're aware that Autumn Quinlan tried to set up a visit with me at the jail,
I don't remember that.
and it was blocked by someone at the jail?
Like a video visit or?
Yes.
I'm not aware of that. I don't remember that.
You have no knowledge that Autumn Quinlan tried to set up a visit with me and she showed up for it and it was blocked?
No, I'm happy to, if you want to refresh my memory with something, but I don't remember that.
Would you be able to check that?
I could, but I didn't go in and see which visits were denied or anything like that.
Would that be something that you would be able to check into?
I could,
Okay,
but I did not.
okay. And if there were a protection order there, it would be something that they would catch and block, correct?
Sometimes there's a lot. They try their best, but they're human too. They can't catch everything. But the restrainer is one-sided. She isn't restrained from doing anything.
But had that gone through, I would have been the one who gotten in trouble, correct?
Only if there was contact, I believe. I don't know administratively, you could have gotten written up, but I don't know.
And every time, even out there, it was a one-sided restraining order, correct?
Yes, you were restrained. She was not.
And even though she was contacting me out there, I was not allowed to contact her, correct?
She was contacting you how? Because in jail, you have to
No,
make the phone calls.
I mean, before I went to jail. Before
You guys were in
before I was arrested, yes.
Object to lack of personal knowledge.
I'm saying,
Sustain the objection.
okay. You were aware that Autumn and I were in contact before I was arrested, correct?
Not until later on in the investigation.
But you found that about subsequently, right?
But doing follow-up and finding some reports, yes.
Yes. And you subsequently found out that the night I was arrested, Autumn Quinlan and I and our children were together, correct?
Yes.
And you found out that pretty much leading up to that, we were together quite a bit, correct?
I don't know how much you were together. I know you were found together with your children that one day.
Okay. And you did no investigation into any of that before that?
My investigation was into what was charged and the information that she provided. That was a separate case. I work in the district court portion, and I don't work into the county court stuff.
Okay. It's true that Autumn Quinlan told you that she told me she wanted a divorce on 9/4/23, correct?
That you wanted a divorce?
Hmm.
I don't remember. I know it went back and forth where she had tried to fix it back and forth. If you have something to refresh my memory,
Yes, I
I'd love
do.
to see it.
I do. Thank you. I have, if you give me just a moment, I'm sorry. I apologize. I have it. 4-6. I have it right here. Right here. Yep. May Mr. Lemus approach the witness, Your Honor?
Yes, can you please let me know what you are showing, Ms. Vick, so that the district attorney has an opportunity
It's
of that and what it is?
it is a Weld County District Attorney's Office supplement page.
Just show it to me.
Oh, I'm sorry.
Yeah,
Yes,
show it
sir.
to me.
Sorry about that.
Yeah, that's fine.
Thank you, sir.
Yeah.
And it's the top line.
Okay.
Dated from 2023.
Okay, thank you.
Did that refresh your memory a little bit?
Yes, she wanted a divorce.
And that's what she told you, correct?
Yes.
But isn't it true that you found no evidence of that in any of the videos I provided you to watch?
Objection.
Before?
Objection. Calls for the witness to testify about evidence not admitted.
Sustained.
Okay, then, did you ever find any evidence of that?
Of her filing for a divorce?
Okay, but that was after the fact of that date?
I'm sorry, I don't understand what question you're asking.
Okay, did you find any evidence of that before that date? Did you find any evidence of that after the fact, you know?
I'm sorry, is your question
I'm sorry, I
before?
apologize. I'm saying before 9/4/23, did you find any evidence of that and anything to support that was the fact, that was the case before that date?
I don't think I looked for that specifically before September 4th of 2023.
And nothing supported her claims of that to that point, correct?
Objection, argumentative, vague.
Sustained in part. Mr. Donison, if you can rephrase your question.
I guess. Let me think how to rephrase this, Your Honor. Well, through your investigation, you know, through your investigation, you didn't find any other evidence of her claims being validated of her claims for wanting divorce, other than the fact that she filed for divorce after this.
As I say, you are divorced, so no, I didn't look for that.
Well, we were divorced much after this, correct?
Yes.
And everything indicated that this was not the case at that point, correct?
I'm not sure what you're asking.
I'm asking that did you do anything to investigate this claim? I mean, there was Miss Fick, I know you listen to a lot of my phone calls, correct?
Yes.
And I know that there were a lot of evidence out there besides what she told you, correct?
I would not agree with you.
Did you ever think to ask about the videos that were out there?
So I'm a fact finder. I follow the evidence. And at that point, I didn't have any evidence that there were additional things that I needed to follow up on.
Ms. Fick, is it your testimony today that Autumn Quinlan never told you that there were videos out there of her?
She did mention videos, but she didn't have them.
But she did have them in her possession at one time. She did have my phone, correct?
I don't know if she had your phone.
She had my phone in her possession in Aurora?
I don't
Correct.
know if she had your phone.
Ms. Fick, you're a fact finder of evidence, correct?
I'm a fact finder.
You're a fact finder, and evidence would be facts, correct? That would be something working toward facts, right? Evidence is something working toward finding out facts, correct?
So there's different types of evidence. What specifically are you asking?
I'm asking you, how do you work toward a conclusion?
So investigations are always ongoing. There's always more to find as people talk. There's more to follow up on. And I just follow the evidence as best I can. I'm human also. I'm probably not going to catch everything.
Well, you wrote multiple reports. You've
Probably over 50.
Oh, I would say probably over 100,
Probably.
correct?
Yes.
And do you recall in your reports mentioning that I got my phone back from Autumn Quinlan?
No, if you want to refresh my memory, I don't.
Alrighty.
Mr. Donison, why don't you move on to your next topic? So we're
Okay.
not delaying and any
Okay,
longer. You can always
Yes,
come back
ma'am.
to this.
okay. All right. So I guess on the same note, Ms. Quinlan said in the same report I just showed you, in the highlighted portion, Chris threatened to use the videos he took against her because she told him she wanted to leave him, correct?
When she was having a PTSD moment, you would record her. Yes.
In just PTSD moments.
I believe that's what it says in there.
It does not
When
say,
when she's having PTSD and postpartum,
do I need to show you that again?
I'd love to look at it.
But you what?
I would love to look at it.
Because it doesn't say that.
No, I'm going to object to
Again,
The
it
Let's
doesn't,
sustain as argumentative. If you'd like to refresh your recollection and bring her the report to review, you may do so.
it doesn't say that, but okay.
I'm going to instruct the jury to strike that and disregard that last statement. Mr. Donison's statements are not evidence and they're not testimony.
Thank you. I was just gonna.
Now, again, I'll ask you, word for word, it says, Chris threatened to use the videos he took against her because she told him she wanted to leave him. Is that
Yes,
what it
in that
says?
report, that's what it says, but there are other reports that say additional information too.
So now you remember what other reports say, but you can't remember other things I say, correct?
objection argumentative.
Sustained.
You have a great memory of those other ones, don't you, Miss Fick?
Objection.
Sidebar, please.
Fine.
And I'll remind the jury that Mr. Donison's statements are not evidence. I am going to instruct them to disregard his last statement. You may ask your next question.
Okay. Okay. All right, and so in the same statement, in the same report you wrote, okay, let me back up. Ms. Fick, Ms. Quinlan testified that I told her I threatened to bring my guy friends over, right?
Yes. And she told me that as well.
And she told you that as well. And you took that as and I take that as you took that as an insinuation that I was going to invite people over to sexually assault her, correct?
That is what she told me.
And that's what she told you, right?
Yes.
But in your statement here, again, it says, Autumn started to get emotional and felt like he was going to invite some guy into their home to sexually assault her. And it was a
Objection to
trigger.
this. Objection. Rape shield.
Sustained.
So again, can I?
So, Mr. Donison, we can have a sidebar.
What is the? Yeah, about the trigger. So again, it says here, Autumn started to get emotional and felt like he was going to invite some guy into their home and sexually assault her. Felt that he was going to sexually assault her.
That was her state of mind. She told me and I documented it. I didn't insinuate anything.
I didn't say you insinuated anything, correct?
Well, you said in the earlier question I did.
Well, and then you said, yes, you did. Then your statement was you did.
I didn't. I documented what she told me and that's what's in the report. She did state that to me.
Okay. And then, well, you didn't say anything in your statements about that she told me that I said that. Correct?
Didn't say you said that. I wrote down what she told me and that's what's documented in the report.
But she testified that I said that yesterday, correct?
I can't comment on someone else's testimony. I can tell you what's in my report.
But you were sitting right here, correct?
Yeah, I'm going to object at this point. I think the evidence speaks for itself and the jury can rely upon their own recollections as to what was testified to.
Sustained.
So, for the record, do you need to be refreshed on what this says here?
I do not.
So, does it say?
And I'm going to object
She
to ask
felt-
and answer it at this point.
Sustained.
Okay. So just for the record, you do not remember if she said, I said yesterday that I said I was going to bring some guys over to do something to her yesterday.
Same objection as to testifying as to Autumn Quinlan's testimony.
Sustained. Mr. Donison, she can't comment on someone else's testimony.
Okay. Ms. Vick, did Autumn Quinlan ever tell you, did Autumn Quinlan ever deny assaulting my grandfather?
Yes,
Whatever.
And that would be on document. Would you like to see the document where she denied that?
I told you she did deny it. She did
Okay.
not.
Okay, and then did she ever admit to assaulting my grandfather?
Object to 401, 403,
Sustained.
404.
But that is also in another document they provided.
Sustain the objection, Mr. Donison. Move forward.
She admitted to assaulting him. No documents. Right here. On 11/24/25, did Autumn Quinlan admit to acts of violence against me unprovoked?
Objection 401, 403, 404, 405.
Sustained.
On your supplement in the discovery, you listed the photo you have of the massage gun as a photo of the massage gun used, correct?
I went through with Autumn and she identified that that was very similar to the one that she had. She bought at the Sam's Club. And that's why I found it on the internet that was similar. She showed the attachment that was used and I put it into discovery and into a report.
But you labeled it as the massage gun used, correct?
If that's what it says, yes, it's a similar item. Obviously, it's not the same one because it's a stock photo.
But why would you label it as the one used when it is not?
Like it's semantics, it's just wording.
But it's an investigation. Semantics aren't evidence.
The item to get a representation to present to a jury on what that item looked like because we did not have it.
Who was the lead investigator on this case originally?
I'm lead for the DA's office and then Juan Mateo is for Greeley.
It wasn't Donovan Serafino?
No,
You're testifying under oath that it was not Donovan Serafino originally on this case?
he was part of the case, but he was not the original one. Juan Mateo was.
So then why didn't Juan Mateo go in and search for evidence?
Objection, Your Honor. She can't testify to the actions of another individual.
Sustained.
Are you aware that Juan Mateo said she was not the lead officer yesterday?
Same objection to testifying as to the statements of another witness.
Sustained.
Officer Juan Mateo testified yesterday that she was not the lead officer, that Officer Donovan Serafino was the lead officer, and that she did not go and collect the evidence for that reason, correct?
401, 403, again, asking to comment on the testimony of another witness.
Sustained.
Do you, why were there no photos of the original quote-unquote crime scene?
I took photos off of Zillow because at that time, by the time I was involved, the parties were no longer at that house. So I wanted to get a representation of what the layout looked like. I can't comment on why that wasn't done.
Was there any explanation ever given as to why no one ever went into the home?
Objection, lack of personal knowledge.
Sustained.
Was there Were there any reports ever given to you as to why no one ever collected any evidence?
You have the same discovery I do. I don't believe so. I don't think anyone documented that.
Was anyone ever hindered from collecting evidence?
Well, there are certain rights that people have, especially inside their homes.
But to your best knowledge, no one ever told them no.
I don't know.
Autumn Quinlan was on the lease there, correct?
I don't know. I didn't obtain a lease.
Chase Arroyo lived there, correct?
He was there when this incident occurred.
And Autumn Quinlan most certainly lived there, correct?
She lived there during what time?
At this time, obviously.
Yes.
And she could have most certainly given permission to go in the house, correct?
She could have given permission, yes.
And to your best knowledge, she didn't deny anyone access there, correct?
I don't know if she was asked.
And to no one's knowledge, my grandfather did not deny anyone access, correct?
I don't believe anyone asked him.
You don't believe or you don't know?
I don't know.
But the truth is that no police officers entered that home and got any evidence.
I don't believe the officers entered the home.
So you can't say for certain that any weapons allegedly or factual existed.
Witness statements are testimony. It doesn't have to, there's different types of evidence. It could be testimony, it could be physical items. So there were testimony and from witnesses that there was a weapon.
But you can't say for your certainty that those weapons existed.
Object.
because
It's
you
a
don't have
improper
evidence.
question. It asks for a legal conclusion, invades the province of the jury.
Sustained.
But you don't have the physical evidence, do you?
We do. I have photos. We have a broken orbital bone. We have injuries from the scene. That is physical evidence.
But you don't know how, but you can't say for certainty how that happened.
We have witness statements that corroborate that.
And you also have multiple conflicting statements.
I don't believe so. Every witness sees something different. Not everyone's going to see the same thing.
And you have multiple conflicting statements that were given by the same person.
Can you be more specific? What statements are conflicting?
You have multiple conflicting statements by Autumn Quinlan,
What statements are conflicting?
conflicting statements that she gave on 9/21, correct?
Can you be more specific?
Donison, you need to move the microphone closer, please.
On 9/21, she gave another statement to the district attorney's office, correct?
What statement are you talking about?
When she said that she hit me in the face, correct?
To defend herself and her daughter?
She never said that in that statement. Do I need to refresh your state? Do I need to refresh
Yes,
your
I
memory
would love
of
to
that?
look at it.
Okay, Ms. Fick, can you hand me that statement, please? We have that. It's in the.
I think it's People's Exhibit 100.
Thank you, Mr. Skelton.
This one, it's the Defendant's Exhibit Q.
I'll come back. Okay, thank you. Can I ask a question?
Oh, I mean, still you're familiar with that?
That wasn't a statement she gave to me, but it is a statement that that the district attorney's office obtained. Yes.
Yes. And so again, we have multiple recanted statements. We have the audios, we have this, correct?
We
Yes
have
or no?
one voicemail and one written statement that is recanting because she was afraid.
That's what she says, right?
Yes.
Okay. And later on, after the fact, much after the fact, correct?
After the fact, what?
Much after the fact of her writing this, obviously, Ms. Fick.
So that was written in March and today, is that what you're asking?
This was not
At distance?
This was not written in March, Ms. Fick. Let's get the facts straight here, please.
Objection, argumentative.
Sustained.
September, I'm sorry.
Sustained. You can ask
A
a
voicemail.
proper question, Mr. Donison.
Her voicemail was left September 18th of 2023, correct?
Yes,
Okay. And there was another voicemail, wasn't there?
not to my knowledge.
Okay, there were two, they're listed and they're listed inside, there were two voicemails left according to the discoveries. Okay, I don't know where that one went, but there were two listed in there, correct?
I know of one voicemail that was left.
Well, I don't know what that one happened, the other one either. So I don't know, but, my other attorney, showed me that one, but I don't know either. But, and then there's this on, it says September 22nd, but, I don't know, somebody said it was September 21st,
Correct.
correct? Okay. And then later on, it wasn't until much later that she said that this was coerced, or that it was until much later after we had another falling out, correct? That she said these were suddenly coerced, or that they were anger. I was in jail, correct?
I believe so.
Do you believe so or no so?
Can you give me a time frame of what you're talking about? Because you're kind of encompassing everything.
Ms. Fick,
What date?
do you not know when I was in jail? You know a lot about this case, correct?
I do.
You've been all over this case for quite a while.
Yes.
I mean, you watch everybody I talk to, correct? You're all over everybody's Facebook that I talk to, correct?
I monitor as part of the investigation,
Yes.
all of the comments you state about the case,
Yes.
your correspondence.
You watch everybody I talk to, correct?
I don't watch everyone you talk to.
Miss Fick.
I don't
you
have that
do,
time.
though. Miss Fick. You know when I was in jail, correct?
Yes, I don't know the specific dates, but yes.
Okay, so you know I was in jail when she wrote this,
Yes.
and you know that she didn't start recanting her statements until much later, correct?
Yes.
Okay.
But you were still in communication.
Yes, and she was with me for a lot of times, but I was in jail for these times. But I was not in jail. I was not in contact with her at this time. Correct?
During that statement?
Yes.
Yes.
Yes, I was not in touch with her at this time.
You were in custody at that time.
Yes, but I
I
was
don't know
not.
if you were communicating at that time, though.
Can you explain to me how I could have been?
If you were in custody, a
I
phone
was-
call?
No, I was at this time when Miss Fick. Do you realize that I was under arrest when she was in? Do you understand that I was under arrest in the police car while she was at the district attorney's office when she was writing this?
I'm not aware of that.
Were you made aware that she was on the phone with the police telling them that she assaulted me at that point?
No, I'm not aware of that.
Did the police officer didn't tell you that?
No.
When he was making her aware that I was being arrested, that she was telling her that she had assaulted me?
Which police officer?
Whoever it was that arrested me that day.
I do not know. I did not talk to those officers.
So you're aware that there was no way that I could have told her to recant that day.
I don't know.
I was nowhere near a phone. I was nowhere near a way that I could have done that. Are you aware of that?
I am not aware.
Okay. So the officer that got the call that day, or the one that arrested me that day, was Officer Perkins. Are you familiar with him?
Yes.
And you never received news from him that she had recanted that day on the phone?
I specifically did not. I did not speak to Officer Perkins.
And he did not recall, he did not refer to you that, or recall to you today, or that day, that she had made references that she had recanted that day to him?
I have not spoken with Officer Perkins. He didn't tell me
Okay.
anything.
Okay. Just a second, Your Honor. So at one point, did Ms. Quinlan tell you that I broke her phone?
Which phone?
The phone that was shattered?
No, I believe she said she used a hammer to get out of the house and she smashed it herself.
But at no point, she had never said that I broke that phone?
Not the phone that she turned over to Greeley. I don't believe so.
I want to make sure that I'm getting this right. But so it was stated that I fled from the house that day, correct?
Who stated you fled from the house?
It's been said, multiple accounts that I fled from the house.
You were not at the house when they went back there, yes?
But does that mean that I fled or that I left?
Objection. Asking for the witness to make some type of determination that's up to the jury.
Sustained.
Let me see here. Ms. Fick, have you ever had a chance to speak to any of the parties? Have you ever spoke to my grandfather about anything in this case?
Yes, I interviewed your grandfather on the phone.
And did you ascertain anything from that?
Objection. Hearsay.
Sustained.
Did you have a chance to speak to Mika Villa?
She just was with Autumn one time with court, but I haven't spoken to her directly.
You're aware that Ms. Quinlan alleges that my 80-year-old grandfather pulled me off of her correctly, or correct? That you're aware that one of the versions of Miss Quinlan's strangulation story is that my grandfather pulled me off of her, correct?
Are you talking about the July incident?
Yes. Is that he pulled me off of her in a headlock?
I don't remember those details. I know that he was trying to block when she went into the bathroom. He was trying to block the two of you and trying to mediate.
Excuse me, 1 second. And what was the recollection on that again with my grandfather?
I believe in the July incident that there was some type of separation. He was trying to block when she went to the bathroom. He kind of stood in between to keep you guys separate.
And you don't recall that she said that he put me in a headlock.
I don't remember.
That she said that he put me in a headlock to rescue her, to get me to stop.
I don't remember the headlock.
Okay. I'm trying to find that right now okay. All right. I just need one moment, Your Honor, because that was a kind of a key point, and then I just want it, and I'll be,
So, Mr. Jonathan, you can certainly look for that, but I would
Yeah,
suggest if you're.
I'm almost done.
Questions to continue to do so, because
No.
we're taking up
Yeah, I'm almost done.
multiple minutes in between each question.
No, I'm almost done. I'm pretty much done. But I'm wrapped up pretty much. I just want to make sure that at this point, before I wrap up, before I'm done, it's, that I'm pretty much done. I just want to make sure before I close, it's,
I'm fine with proceeding to redirect and allowing Mr. Donaldson to ask that question on recross. That gives him some
Right,
time
it's,
to look into it.
Thank you.
let me see here. Where's some of the allegations, photos with any certainty. I appreciate that, Mr. Scott. No further questions, Your Honor. Thank you.
Thank you, Mr. Skelton, and redirect.
Yes, thank you. All right, Investigator Fick, I'll try to start again, like in order of the questions the defendant asked you. So the defendant asked you a number of questions about Autumn and a statement she made about wanting to file for divorce and whether she had done any of that prior to September 4th of 2023. Do you remember that line of questioning?
Yes.
Your Honor, I'd ask the court to take judicial notice of 23 DR 252, domestic relations case from March of 2023, where Autumn Quinlan filed for divorce from Christopher Donison.
Court will take judicial notice.
You were asked some questions about the jail calls, and you didn't listen to all the calls in this case, right? You didn't listen to all the defendant's jail calls.
No, I didn't.
How many jail calls did you pull in this case?
Oh, thousands, a lot.
Some of them could range from a couple minutes long to 30 minutes long, hour long.
Each jail calls a max of 15 minutes, but yes,
And then it may break up into multiple calls, even though it's one conversation.
correct.
You have other jobs of being the investigator on this specific case. Is that right?
Yeah, and many other cases.
And so I think one of the things you testified to is that when you're trying to maybe triage and look at what calls might be most relevant, you're going to look around court hearings and stuff like that.
Correct.
Could one of those potential like dates that might have relevant information is after someone's been recently arrested on something, an issue with a bond or an issue with a protection order or something related to a case?
Yes.
And now specifically in this case, we've been referencing People's Exhibits 24 through 27. Those are the calls between the defendant and Ms. Quinlan from November, I think 13th, 14th, and 15th. Is that right?
Yes.
And isn't it correct the defendant was arrested literally, I think, the day before on November 13th, the night of November 12th, for protection order violation out of the protection order in this case?
Yes.
Now, you were asked by the defendant why you didn't investigate Autumn Quinlan's scheduling visits with him in the jail or Autumn Quinlan calling him when there was a protection order. Why didn't you investigate that?
Yeah, those are like side kind of things that don't comply to the criminal case and the elements of that. So they had nothing to do with this case.
Is it a crime for Autumn Quinlan to call the defendant when she's not subject to a protection order?
No.
And in fact, the defendant referenced when he was found with Autumn and the kids and then arrested that night, is there actual a separate investigation and a separate case based upon that where a separate investigation was done?
Yes.
You were asked a number of questions about, videos. And I think Autumn, even in the Greeley Police Department lobby on September 4th, 2023, in that video we watched references the defendant recording her for PTSD,
Yes.
right? And that you did not elect those videos. Is that fair?
Yes.
Okay. Fair to say you cannot force people generally to turn over evidence to you,
That's right. We can request it, but it's ultimately up to them.
particularly defendants in criminal cases.
Yes.
Okay. Now, if someone had provided you a bunch of videos, would you have said, no, please don't give me those?
I would have taken them, collected them as evidence, and written a report.
But that didn't happen.
No.
And fair to say there's a difference between what someone may think is relevant and what is admissible in a criminal trial. Is that fair?
Yes. Very different.
And also, when it comes down to seeking a warrant or that type of thing, you need to have evidence of criminal wrongdoing.
We do have to have some nexus to it and criminal wrongdoing and not a long delay or staleness.
And so you can't just go and request a warrant to seek potentially evidence that may be useful to a defendant if they're not going to turn it over to you. There's no obligation to. Fair?
Right.
Now, you were asked some questions by the defendant about Ms. Quinlan's statement on September, I think it's dated September 22nd, the written statement, and then the voicemail that was left some days before that. Do you remember that line of questioning?
Yes.
And you were asked, I think repeatedly, like, well, you say she's not giving conflicting statements. What about these recantation statements? Remember that line of questioning?
Yes.
Okay. Did you consider those conflicting witness statements?
No, I didn't.
Why not?
She's in a relationship and it's hard when there's a lot at stake, and it's normal for someone to be in and recant because they're afraid of what may happen, what might come of it, what their life may look like. So it is common to see recantation in cases like this.
And that's kind of based on what Autumn Quinlan told you later on. Fair?
Yes.
And again, you'd agree it's up to the jury to decide what, if any, statements to believe, and it's their job to determine credibility. Is that fair?
Correct.
Okay, but the defendant asked you why you thought specific statements were consistent, so I just wanted to follow up. Now, you were asked a question kind of similar to that line of questioning about Officer Perkins, and that was the Greeley police officer, one of them who was present when the defendant was arrested, I believe on September 21st. Is that accurate?
Correct.
And you said you didn't follow up and call Officer Perkins. Is it fair to say you did, at least in the discovery, includes Officer Perkins' report from that arrest?
Yes, and his body cam.
And you said you were, prior to becoming a DA's investigator, you were a patrol officer with the Weld County Sheriff's Office, right?
Yes.
You've been trained in report writing, correct?
Yes.
And so if there's something significant or important in a case, if you're even touching it in some way, you're going to document it in a report, right?
Yes,
Law enforcement's been trained to do that. Fair?
we are.
nowhere in his report is there a statement that Autumn Quinlan recanted to him that day, is there?
No, there's not.
Now, you were asked some questions about speaking to James Benefit and things like that. And obviously, you're not going to testify to statements someone made at a different date and time, but fair to say, I've asked you a number of questions about intercepted jail communications, and there have been a number of calls between the defendant and Mr. Benefit. Fair?
Yes, there are.
Leading up to the trial today.
Yes. That is his main person he contacts.
Thank you. Actually, you know what? I just want to follow up with one more thing. There was that statement the defendant was showing you on the report, and I believe it was the report from your very first initial meeting with Autumn, where it was referencing her statement about he took those videos because I think one of them wanted to leave each other. I can't exactly remember who it was, right?
Right.
And then I think one of your responses was, yes, in this report it doesn't reference PTSD, but that's later reports.
Yes.
And I think you previously testified you wrote somewhere, is around 50 reports sound right on this main case?
Yes.
And you met with Autumn Quinlan multiple times between December of 2023 and up until today's trial, is that right?
Correct.
Would you agree that kind of her statements and her openness to talk about this kind of evolved and got larger over time?
Yes. As she became more comfortable, she kept remembering other things and being more open.
Okay. And so one of those things you talked about was that initial report didn't include a statement about this was PTSD, but later ones did. And it's also on that body worn camera from the GPD lobby on September 4th of 2023.
Correct. Yes.
Thank you. Those are my questions.
Thank you, Mr. Donison. Any recross?
Yes. You mentioned that Officer Perkins from the day of my arrest didn't mention that Miss Quinlan recanted, but did you review his body-worn camera?
I have reviewed his body worn camera.
And there was no conversation with Miss Quinlan?
I believe there's a phone call, but I don't remember anything about recanting.
And what was that conversation about?
Your
Objection, hearsay.
Sustained.
And it is your testimony under oath today that you did not hear anything about Miss Quinlan saying that she hit me that day on that phone call, or there was nothing about a recant
Objection, hearsay.
that day.
Sustained.
To your recollection, is that still in preservation?
yes, and in discovery.
That his body worn camera is still in preservation?
Yes, it's in discovery. It's in evidence.
I want that. I want that. I want that. I want that preserved. I'm gonna get her testimony. Mr. Skelton mentioned the video evidence and something to the effect that that you wouldn't necessarily collect something if it didn't contain proof of crimes committed, correct?
What videos?
Or anything, you wouldn't really go after something if it wasn't necessary.
Right. We could go down rabbit holes all day. So yeah, we do follow the evidence. If it's not a crime, then that's my job is to investigate crimes.
So when Autumn Quinlan was telling you about videos that were out there, you didn't really see fit to track them down?
She wasn't under investigation though. I didn't track down the videos. No, I didn't.
You, was that because it didn't, it didn't interest you, or it wasn't, was there a reason for that?
I just didn't think it was relevant to this investigation. I didn't know what was contained on the videos.
She didn't tell you?
She just said there were videos of her that you would randomly just start recording her when she was kind of going through episodes.
Didn't she tell you there was one where she was holding me in a car and I jumped out?
She said that there was an incident where you jumped out of the car when she was driving.
And she didn't tell you it was where she wouldn't let me out of the car?
I don't remember the specifics. I just know that you wanted to get out of the car and you jumped out of the car.
And she didn't tell you that was because she wouldn't let me out?
Objection, 401, 403, hearsay, evidence not admitted.
Sustained.
So at no point you never became interested that these videos might be pertinent to this incident?
I didn't know who had them at the time because I don't believe that she had them on her phone.
Ms. Fick, is it your testimony that throughout my thousands of phone calls, as you testified, that I made a point, let me rephrase this. How do I say this? I've made it a point to speak about those videos in hundreds of calls. Isn't it true?
You have talked about those videos a lot.
In hundreds of calls, because I want you to hear about those calls. Wouldn't you say that's true, correct?
You have certain rights too.
Because I want you to hear about those
Objection,
videos.
she can't testify to his intent.
Sustained.
I think she can, because you think you know I want
Mr. Donison, I've sustained the objection. Move forward, please.
Ms. Fick, would you say that a lot of times you think I'm talking to you on those calls?
Objection, same objection. Can't testify to his intention. It's for
Sustained.
speculation.
Ms. Fick, were you ever interested? Was on those videos that was pertinent to this case?
Not really.
No, even though the videos were dated from the dates of this incident.
Objection, asking for testimony on inadmissible evidence.
Sustained.
Okay. Okay. No further questions.
Thank you. Do any members of the jury have any questions for Investigator Fick? All right, Investigator Fick, a couple of questions from the jury. Can you elaborate the differences between the DA side and the police side applied to this investigation?
Sure. So when this case originally was dispatched, the Greeley Police Department took the initial call. They did their investigation, collecting evidence and talking to witnesses. And then once they felt like they had enough probable cause or enough to file charges, they sent it to the DA's office. Charges were filed. And then once charges are filed, and there's either a warrant or that person's arrested, then I kind of take over the investigation and fill in the holes that they don't. Like, for instance, interviewing James Benefit, talking to Tom Packard, maps and locations, and just getting more information that they might not have gotten from the victim initially. And then I go through all the way through the court process with this case.
Thank you. Did the victim explain to you why the defendant would record her during PTSD moments?
She just said that there were times that she was going through postpartum PTSD and that he would record her threatening her to take the kids away and use those videos to do that.
All right, Investigator Fick, who can request visitations on the outside or inmates only, or can they both request visits?
So when it comes to jail, like video visits, everything's digital now. They don't do in-person visits. So they would have to set up an account and then it would have to be approved by the jail staff. They have to provide an ID, the relationship to the inmate. And then once it's approved, that visitor would set up those calls because they would have to pay for them.
Thank you. Mr. Skelton, any follow-up questions based on the juror questions?
No, thank you.
Mr. Donison, any follow-up questions based on the juror questions?
Was there ever any proof that I was trying to take the children from Miss Quinlan?
Objection in calls for the witness to give a conclusory opinion, one on an issue not before this court, it is not relevant to this case, that she does not have personal knowledge of.
That's fine.
Under 403.
Well, I was just asking if there was any.
Mr. Donison, I've sustained it under 403.
Okay. Did you ever have any reason to think that I was trying to take the children from Miss Quinlan?
I can 401, 403.
Sustained.
Personal knowledge.
Okay, no further questions?
Thank you.
Thank you, Ms. Vick. You may step down. All right, Mr. Skelton, do the people have any additional witnesses?
We do not, Your Honor. At this time, the people rest.
Thank you. At this time, the court does need to work on some things with the parties. So we're going to take a break. And generally, it usually takes a little bit longer than our normal just morning breaks. I'm also concerned that we're going to run into the noon hour. So I think it makes sense to go ahead and give you an extra long lunch today. So I'm going to ask if I could have members of the jury back on the second floor at 1:30 to continue with the trial so that the court can work with the parties here in the courtroom. I do need to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. Finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of the trial. Again, if I could have members of the jury back on the second floor waiting area at 1:30. All rise for the jury. Thank you. You may be seated. We are outside the presence of the jury. Are there any motions at this time?
Yes, Your Honor. Give me 1 second. Let's read this.
It's right here.
Read this right here. Your Honor, I'm moving for a judgment of acquittal.
Any additional record you'd like to make with regard to that?
Yes, Your Honor.
Just all this equipment.
Pursuant to Rule 29A of the Colorado Rules of Criminal Procedure, as I said, the defense now moves for a judgment of acquittal on the charges of assault in the second degree, count 2, menacing, count 3, assault in the third degree, count 4, false imprisonment, and count 5, child abuse. presented by the state in its case in chief, both direct and circumstantial, when viewed as a whole in the light most favorable to the prosecution, is insufficient to sustain a conviction of guilty. The state failed to prove beyond a reasonable doubt all of the elements of the crime charged. The state has failed to offer any credible evidence in regard to the defendant.
To start, I agree.
Of relevant evidence will not rationally support a conviction beyond a reasonable doubt. Furthermore, verdicts in criminal cases may not be based on guessing, speculation, or conjecture. Here, both of these principles of law would have to be relied upon in order for the jury to return a guilty verdict in this case. The Due Process Clause of the United States of Colorado and Colorado constitutions prohibit the criminal conviction of any person except on proof beyond a reasonable doubt. Because the evidence presented thus far is insufficient to sustain a conviction of these charges, the defense now moves this court for a judgment of acquittal. Thank you, Your Honor.
Thank you. Mr. Skelton.
Just briefly, we're laying out the evidence in the record supporting each of the charge counts going over to the jury. I'll note I'll just go in chronological order. Second degree assault, strangulation, as alleged to have occurred on July 24th of 2023. Ms. Quinlan identified the defendant as the one who at 1600 Fairacre, which was testified to as being in the county of Weld, state of Colorado, wrapped a sock around her neck, applied sufficient pressure to her neck to restrict her breathing, causing her to go unconscious. As to the offenses alleged to have occurred on September 4th of 2023, as to the second degree assault, there is testimony that again, it was the defendant at the 1600 Fairacre residence inside their downstairs bedroom, struck Ms. Quinlan in the face with a closed fist, breaking her orbital bone, which was testified to by a nurse Lackey who viewed a CT scan that very same day at the hospital, which showed the fracture, which is sufficient for an SBI finding under the second degree assault statute and the definition of serious bodily injury. As to false imprisonment, Ms. Quinlan testified she was not allowed to leave that downstairs bedroom area. At one point, she tried to leave and was pushed down on the bed, and the defendant repeatedly told her she was not allowed to leave. Felony menacing, she testified that the defendant pulled a knife on her, threatened to slit her throat, and threatened to cut off her warrior tattoo, which would have put a reasonable person in imminent fear of either serious bodily injury or death through the use of a deadly weapon, i.e. a knife. And finally, the child abuse charge supported by the testimony of both Autumn and Chase that Lily, a child whose age was testified to as being a child under the child abuse definition, was in Autumn Quinlan's arms while Autumn Quinlan was repeatedly assaulted by the defendant, and that Lily was actually struck by punches, even though actual physical injury is not a required element of that offense. And so for those reasons, the people believe there is sufficient evidence in the record for the court to submit the charges to the jury. We'd ask that the motion for judgment of acquittal be denied.
Thank you. When deciding a motion for judgment of acquittal, the standard the court must review is in People v. Bennett, 515 Pacific 2nd, 466. Is the relevant evidence both direct and circumstantial when viewed as a whole in the light most favorable to the prosecution, substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty beyond a reasonable doubt? Court is bound essentially by 5 well-established principles of law. The court must give the prosecution the benefit of every reasonable inference, which might be fairly drawn from the evidence. Court does not take into account credibility, as that is the sole providence of the jury. The trial court may not serve as a 13th juror and determine what specific weight should be accorded to various pieces of evidence or by resolving conflicts in the evidence. Court also will note that a modicum of relevant evidence will not rationally support a conviction beyond a reasonable doubt. And then ultimately, a finding of guilt may not be based on guessing, speculation, or conjecture. In this case, the court has heard from a number of witnesses thus far, but specifically has heard from Autumn Quinlan, Chase Arroyo, Allie Lackey, Officer Juan Mateo, Thomas Packard, Alyssa Roton, and then investigator Jennifer Fick. Court does find that there is sufficient evidence on the record at this point to substantiate this case moving forward to the jury. Court does find that, strike that. Court does deny the motion for judgment of acquittal at this time, finding that there is sufficient evidence to sustain a conviction on each of the offenses. All right, thank you. I know that, Mr. Skelton, you wanted to address an issue with witnesses, but I want to go ahead and go over the Curtis advisement first.
Sure.
I also want to rule then on the motion in limine. Because frankly, I do think that ruling is needed for Mr. Donison to make a informed decision about whether or not he chooses to testify, but I'm still going to go over the Curtis advisement. The motion in limine that was submitted by Mr. Donison yesterday with regard to felony conviction is denied. There is not only statutory support for cross-examination of the defendant, which allows the admission of prior felony convictions, but there's also case law to support that. Statutorily, it's permitted under 1390-101. There is, again, case law that supports that, indicating that there is no due process violations in allowing admissibility of prior felony convictions, the purposes affecting credibility. That's People v. Montez, 589 Pacific 2nd, 1368. Also supported by People v. Layton, 612 Pacific 2nd, 83. As well as People v. Griffin, 595 Pacific 2nd, 231. So I am denying the motion in limine. Okay. Mr. Donison, I am going to go over the Curtis advisement at this time, which goes over, frankly, your right to testify or not testify in this case, okay? All right, so Mr. Donison, do you understand that you have a right to testify in this case?
Yes, ma'am.
Do you understand that if you want to testify, no one, including your advisory attorney, can prevent you from doing so?
Yes, ma'am.
You understand that if you testify, the district attorney will be allowed to cross-examine you the same as any other witness?
Yes, Your Honor.
Do you understand that the jury may submit questions subject to the same rules of evidence and procedure that apply to the parties asking questions, and that improper questions will not be permitted, and legally proper questions may be asked if you choose to testify?
Yes, Your Honor.
Do you understand that if you have a felony record, which the court understands that you do, the prosecuting attorney will be allowed to ask you about it?
Yes, Your Honor.
Do you understand that if your felony record is disclosed, the jury will consider your record only as it bears upon your credibility?
What does that mean?
That means that the court will provide a jury instruction to the jury indicating that your felony record is only to be considered as it bears upon your credibility.
And what is to be presented at that point?
As I indicated, the court will instruct them via a jury instruction that they are only to consider your felony record as it pertains to your credibility.
Oh, it's just the felony record?
Correct.
Okay.
Do you understand that you also have the right not to testify in this case?
Yes, ma'am.
Do you understand that if you decide not to testify, the jury will be instructed that your decision may not be used as evidence of your guilt and will not prejudice you in any way in the eyes of the jury?
I do, Your Honor.
Have you discussed your decision whether or not you would like to testify with your advisory counsel?
Not in depth, Your Honor. I haven't decided yet.
All right. We'll give you some time to speak with them. Do you have any questions about your rights?
Not at this time, Your Honor.
All right. Thank you. All right, then, Mr. Skelton, you indicated that you wanted to address witnesses.
Yes, so I try to be efficient with time. We have a couple of, I'll outline for the court. So I know the defendant has endorsed or listed subpoenas for a couple additional witnesses he did not call at the last trial, specifically referencing here in the people's objection, Officer Albert Castillo with the Fort Lupton Police Department. I believe he was the officer that responded in the November misdemeanor case. That was the violation of protection order. I do not know what admissible evidence that officer possibly could testify to. Other statements are hearsay to the extent there tries to be some untruthful act on behalf of Ms. Quinlan, because I think potentially she gives a false name or says that they're not together, or it's not the defendant. That is an act of untruthfulness under 608 that cannot be proven by extrinsic evidence. So the officer can't testify to that. He's restricted to asking her about it on cross-examination, which he did not do. And so rather than have the concern is him asking multiple questions that are all objectionable. And so I don't see any basis for that officer to testify. The other officer or law enforcement witness that I'm also concerned about is Deputy Richard Meredith from the Weld County Jail, who's the investigator from the Weld County Jail. I think there was some mention by the defendant on cross-examination of Investigator Fick about, was Deputy Meredith telling you things about my case? I'm not really sure what the relevance is here. There was some discussion at some point in this investigation that there was a different individual in the Weld County Jail that was claiming things about Mr. Donison. We did not find those things credible. We did not admit them in this trial. And so I am again questioning the relevance of Deputy Meredith from testifying. And then lastly, which is a separate issue that Mr. Daly will bring up regarding Mr. Benefit, there was another intercepted jail call last night where the defendant lays out exactly what he would like Mr. Benefit to testify to. And so we are intending on using that call and cross-examination of Mr. Benefit. And I don't know when he's going to testify, but it sure seemed like it was going to be today based upon that intercepted jail communication. And so we're going to want the court to listen to it. Likely makes sense for the court to listen to it now while we have time, but I'll let Mr. Daly make any additional record about that because that is his witness. But I did at least want to frame up the issues for the court.
Thank you. And Mr. Skelton, Mr. Daly, before I hear any additional argument with regard to Mr. Benefit.
Hey, can I get the call first?
That was going to be my question, Mr. Donison. I'd appreciate if you continue to stop interrupting the court. It sounds like there may be copies of that you could provide to the court as well as Mr. Donison.
We have transcript copies we can provide. We're just going to be an open court as well outside the presence of the jury so we can all be aware of what so the defendant can hear kind of the tone and everything of the call. But we do have transcripts of what's said as well.
Thank you. Ms. Fick, if you wouldn't mind approaching. Thank you. I appreciate that.
Fine with you. It's a copy already. Okay. And the defendant does have a copy, just for the record.
Thank you. Mr. Daly, anything in addition before we listen to the call?
Just a second.
Sorry, Jen. We're going to come.
Sorry.
As the court's aware, at the previous trial, there was a similar type of record made about violations of sequestration order. If Mr. Benefit does testify today, people will be going into those previous calls from January 2025, as well as depending on the court's ruling here, but plan would go into the call made yesterday as well for impeachment purposes. So just want to put everyone on notice. If he testifies, going to bring up the fact there's sequestration order, both at the previous hearing and the current hearing. There's communication between Mr. Benefit as well as the defendant. One, discussing other people's testimony in those previous calls, and then specifically in this call, here's what you were going to say. That's ultimately what people intend to introduce in terms of impeachment, Your Honor. And people would ask to play the call for the court's benefit.
Can I ask for just a moment? I'd like to review the transcript briefly
course.
first, and then I'll hear it just to
Of course.
make sure I can follow along. Okay, I've reviewed it. I'm happy to hear it at this time.
For English, for a call, please enter your. Please enter the area. Please hold. Please wait while your call is being connected. Please hold. Hello, this is a prepaid call from
Chris Donison.
an inmate at the Weld County North Jail. To accept this call, press 0. To refute, your current balance is $36.66. This call is from a correction facility and is subject to monitoring and recording. Thank you for using Global Tellink.
Hello.
Oh,
What are you doing?
just sitting there watching TV.
Oh, okay. All right. So you can cover what the way back if I get you over there, right?
It's going to cost
I know what-
$150.
What on the all the up there and back, right?
More than that.
Pop, listen, okay? Listen, okay? Is that the fight
Yeah.
of my fucking life? I'm asking you. Is it? I'm
Yeah.
asking you. Okay? This is my life on the line here. Okay? I'm telling you right now. If I'm listen to me, okay? I'm asking you this. I understand it, okay? I've paid more of that. I've paid more of that for shoes, okay? Let me ask you this, okay? I'm asking you this,
Yeah.
okay? If this happens, I will never see you alive again. Do you understand that?
I know that.
Do you understand that?
Yes.
I will never ever see you alive again. Do you understand that?
Yes.
Okay, we need to make this very, very clear. We need to make this very fucking clear. We will never see each other again if this happens. If
Well,
this goes wrong, we will never see each other again.
I know that.
I'm just trying to make this clear that $160 is the difference here. Okay, we've spent more of that on a meal. We've spent more of that on a meal. Okay, we've spent more than
Right.
that on stupid shit. Okay,
Right.
so we need to put this into perspective here. Okay,
All right.
you need to understand that Chase spent that today to come out here from Aurora. Okay,
All right.
I just need you to understand this, that Tina is willing to pay for part of it, okay? I need you to understand this.
All right.
Okay, I'm not asking you to come out here and do anything but tell the truth. Okay?
I'm telling the truth.
That's all I want you to do. That's all I want you to do. That's all.
All right.
Okay? You weren't
We're not
downstairs.
going to be
Pop,
there.
listen. You weren't downstairs, Pop, so you didn't see any of it, okay? All you did was see her come upstairs. That's it. You just saw her come upstairs that day. That's it. And you saw the injuries.
That's all.
And listen, Pop, you saw her come upstairs, and you don't know how those injuries got on her face. You don't know. You don't know anything, Pop.
No.
That's it.
No, I know.
I know, Pop. Listen, I know that, Pop. I know that. Okay. And then what happened after that? You don't know. You know what I mean? You don't know. I know that.
Yeah.
I know that. I don't expect you. I know that. I'm just saying, Pop. And you know all the things that were going on in that house. The rest of the time when we were living there, you know that. That's all.
Oh, yeah.
That's it. You know what was going on in our lives, Pop. You know the things she's done to you. You know the things she's done to me.
Right.
You know that
Right.
you know the things that were going on. That's all I'm asking you to talk about is the truth.
Yep.
Okay? That's it.
Yep.
That's
I
it.
tell the truth.
Pop, listen, that's it. Okay? That's it.
That's it.
But I need you to be there. Okay? That's it. Well, that's
All right.
it.
When
Okay?
I got to be there?
Huh?
When I got to be there?
I don't know. That's Tina's gonna figure out for you, okay?
All right.
Tina's gonna figure that out for you. Okay?
Okay.
I'm just saying, Pop, that's all I need you to do is tell the truth.
I will tell the truth.
That's it, okay? That's what I'm saying, Pop.
I tell the truth.
When she came upstairs, you don't know how those injuries got on her face. You don't know. You don't know. That's the truth.
No, I don't.
I'm just saying. That's the truth. That's the truth of the matter.
That's the truth.
And that's the truth. You don't know.
Nope.
I mean, you saw him. You don't know. I'm just saying. I that's all you know, Pop. I don't know.
Nope.
I don't, I mean, I don't know, Pop. I'm just
I'll
telling
tell
you.
the truth.
I just want you to
That's
tell
all
the
I can
truth. That's all I want you to do.
I'll tell
I'm not going to tell you anybody's
truth.
testimony. I'm not going to tell you any testimony because
Nope.
that's none of your business. I'm just telling you, Pop, that day was a crazy day. And I'm telling you, what happened after that is, I just want you to tell the truth. That's it.
I'll tell the truth, Chris.
I know, Pop, because what unfolded that day was, was a lot of craziness. You were a witness to a lot of stuff, and that house was crazy house.
Oh, yeah.
And you know what I mean? That house was crazy.
Yep.
So you were the witness to a lot of things, Pop, and I need you there. I wish I could be there. You know what I mean? And so I need you there, Pop. $160 is a lot of money to get there. I know that.
All right.
But I'll tell you this, Pop. We've spent money on the stupidest shit.
Yeah. All right. I'll be there. Okay.
All right?
I'll get a whole team first thing tomorrow and find out when I got to be there.
Huh?
I'll get a hold of what's name tomorrow and see what time I got to be there.
Well, yeah. Tina's gonna call, and she's gonna call and find out. She's gonna talk to Zach, and she's gonna find out when you're needed, because they did the same thing for Chase today. They said they found out when he was gonna be there, when he was gonna be needed, and they found out like if he was gonna be needed, and then they found out when he was coming from Aurora, and they were able. He came from an Uber or Lyft or whatever, and then they said, hey, you're gonna be needed, and then it was plenty of time to get there from where he was at.
All right.
All right.
All right.
And then Tina's going to cover. Tina's going to pay for half of it.
All right.
All right. So
Okay.
so dress presentable. Whatever, Pop. Just try to dress presentable. Whatever. Okay.
I will.
I know. I'm not saying you got to
will.
dress up. I know. I'm not saying you got to dress up, Pop. But just wear something. Try to dress as well as you can, Pop. You know what I mean? I know.
I will.
I know. Just all right.
All right.
Just recollect or whatever. Just think it over.
All right. What time do you got to call me tomorrow?
What time am I going to call you?
No, Tina.
Oh, I was going to say I won't.
Let
be
me
able
know
to
when
call
I
you.
got to be there.
Just keep your phone on, and she'll let you know. All right, but it won't be until later on. All right. I love you with all my heart. Okay.
I love you. All right.
All right. Good night.
Good night.
I love you. Bye.
I love you.
All right. Bye. I love you too.
Bye.
Bye. Sweet dreams. Love
Love
you.
you.
Bye.
Bye. Love you.
All right, thank you.
Does the court require any additional record from the people?
I just want to confirm, Mr. Daly, then, the people's intention is if Mr. Benefit testify that you intend on cross-examination to utilize not only this jail call, but the jail call from January of 2025. Is that correct?
Yes, and there are 2 from January 2025.
Thank you.
Yes.
That is correct.
So there'll be 3 in total for this. We're not asking to preclude him from being able to testify. No, that was the record we made at the previous trial. Ultimately here, Your Honor, we're asking to bring this in as it, weighs heavily on credibility.
Thank you. Mr. Donison, any record that you'd like to make with regard to this issue?
Yes, Your Honor. I can see this one here, and I'll say this, I would ask, I object to the other 2 being brought in because this one here, there's no mention of anybody's testimony. And the information that I talked to him about was information that was spoke to with my investigators with Casey Jenkins. It was spoke to with Molly Irwin. It was spoke to, this was stuff, I am my own attorney. I am allowed to speak to my witnesses about information for trial preparation. I'm allowed to speak with my witnesses. I'm allowed to speak to my witnesses like an attorney. I am allowed to refresh memory. I'm allowed to speak to my witnesses. And they're taking that right away from me here. I'm speaking to my witnesses here. I am not saying anything wrong here. I'm not talking about anybody else's testimony, and they're prejudicing me here. They're talking about prejudicing me to the jury. They're talking about outing me here, making me look bad to the jury, and they're talking about bringing something in from another trial. I'm not talking about other witness testimony here again. I did mess up in the last time. I realize that. I messed up in the last trial. I spoke to him, and I spoke to him out of line. I messed up, and I spoke about other people's testimony in the last trial in phone calls. I get that. Those phone calls should not be admitted in this trial. That was in the last trial. I did not do that again. In this phone call, I was speaking to a witness. I am my own attorney. We take off two different, we wear two hats in this, in this situation when we would go pro se. That's very clear in the law, whether it's behind this desk or on the witness stand. And in those phone calls, I have to wear two hats as well. And I have to speak to him. I don't get privacy. I don't get the privacy of being able to sit in a room like these guys do. I don't get to sit with the witnesses like Miss Quinlan and all these guys and be able to prep these guys. I don't get to do that. I don't get the privacy of that. I have Miss Fick in my backside listening to everything I say. I have Richard Meredith in my backside listening to everything I say, recording everything I say. For this reason, I wasn't trying to hide anything. I was not trying to hide anything. I wasn't using anybody else's PIN numbers. I wasn't doing anything. I was speaking very openly. I'm telling him, tell the truth. I'm saying, Pop, tell the truth. I need you up here to testify. Tell the truth. You know what I mean? I'm saying, tell the truth. Just come, tell the truth. And I'm saying, Pop, you just tell him what you remember. You didn't see anything that day. As you told the investigators, you didn't see anything. You don't know how those bruises were created. That's the truth. That's all the truth it is. To play this for the jury is prejudicial. I didn't do anything wrong. I'm just prepping my witness like these guys do. But it's highly prejudicial, Your Honor, and that's my objection here.
Thank you, Mr. Daly. Any response?
Just briefly to kind of sparse out the differences between the phone calls. In the original trial, those were, as the defendant correctly states as well, that was discussion of other people's testimony, specifically Autumn Quinlan's and Chase Arroyo's, to Mr. Benefit, explaining they're lying on the stand, we gotta do this, we gotta do that. Mr. Benefit's testimony, even if we didn't have this new call, is tainted completely. And that's why those calls should be allowed to come in, because his credibility is in question for that. So that's part one. And then part two, I agree, he's not talking about anyone else's testimony here, but he is talking about specifically what Mr. Benefit is to testify about. Specifically, if the defendant had left it at, I just want you to tell the truth, and that was the end of it, there's no issue there. He goes down, really, it's page 3 of the transcript here, beginning at the 9:25, the 3:10 mark, the minute mark. That entire paragraph is the defendant telling Mr. Benefit exactly what to say. That calls into question his credibility. And so that's why not only the original audio calls, but also this one is relevant for the purposes of impeachment for credibility purposes on Mr. Benefit. Thank you.
Thank you. Court's prepared to rule.
And I just want to say for the record, I object under 403 to all three, but especially the first two.
Thank you. It'll be preserved for appellate purposes. Court is going to find that this phone call is admissible. It specifically goes to, frankly, the defendant's consciousness of guilt with regard to 404, but it also goes to Mr. Benefit's credibility, as do the original phone calls back in January of 2025, which the court was the judicial officer that held that trial that ended in a mistrial, had an opportunity to hear those calls as well. This is not prepping a witness. This is specifically according to what the court heard, and not just going off the transcript, specifically what the court heard is the defendant telling Mr. Benefit exactly what to say. You didn't see anything. You saw her go up, Sarah. You don't know how those injuries got to her face. You don't know anything. That's not just tell the truth. I would agree if Mr. Donison had said, you just got to tell the truth and be here, we would not be having this discussion. That's not what occurred. This directly goes to Mr. Benefit's credibility. The previous phone calls also go to Mr. Benefit's credibility, because in those previous phone calls, Mr. Donison, in violation of the sequestration order, then continued to tell him what he heard in the trial as it pertained to the other witnesses. So I don't know Mr. Benefit's ability to remember, but he was told by the defendant previously what Ms. Quinlan testified to, what Mr. Arroyo testified to, that they were liars. And then we are coupled with now Mr. Donison telling them specifically what to say. So I believe that they're relevant under 403. I think they come in under 404. And they directly go to Mr. Benefit's credibility. Is there an offer of proof, Mr. Donison, with regard to Officer Castillo as to what you believe Officer Castillo would be testifying to?
And what is going to be allowed on that?
I would like an offer of proof so we know what your intention is. You're calling this witness.
Let me confer with Mr. Lemus. Well, I wanted him to testify about the night we were arrested, but I'm pretty sure that Mr. Skelton's going to object.
So you want him to testify, and what was the date of that? That was November something?
No, it was November 13th or 12th, 13th, going into 13th.
And how would November 13th be relevant to what happened on September 4th or July 23rd, 2023? Excuse me, 24th.
I think it just goes into everything that kind of, it all just went into the whole, if July 24th, 2023 went into, 9/4/23, then the whole picture of everything that went up all the way into my arrest all the way into 11/12/23 all goes together. I mean, it's all one huge, big picture of togetherness. I mean, it's all goes together. I mean, it's all one big picture of Autumn Quinlan and I. I mean, it all speaks volumes. I mean, that whole year, everything from March 3rd of 2023 all the way on. I mean, it was just one huge insanity ride. Everything. I mean, I don't know what else to say. That was just one tumultuous relationship.
I would just say, I think the officer, I guess, there could be relevance to establish they were together on that day, to the extent the defendant has argued, if she was so terrified with me, why was she still with me? I could see some probative value in establishing 2 months after September 4th, she was found to still be with him. But I don't think any testimonies about what was said or anything like that is admissible over the rules of hearsay or character.
I'm sorry, what was that last part?
I don't think any testimony about the officer testifying as to what any individual said or anything like that, absent an observation that they were together, they were in the vehicle or they were, around each other. I think that could be relevant based upon his previous arguments of if she was so terrified, why was she still with me? So I could see a relevance there, but any actual statements made or conduct of Miss Quinlan that goes towards her character or character for truthfulness and admitting evidence of that, I think would be inadmissible. So I guess now hearing that, I think there is a very, very limited relevant use of his possible testimony here.
With regard to Officer Castillo, if defendant chooses to call that officer, his testimony will be permitted. With regard to really whether or not the parties were together on that date, under 608, any specific acts, strike that, any specific instances of conduct of a witness for attacking untruthfulness is not permitted. So if there is so Mr. Donison, you're on notice. If there's a question of what Ms. Quinlan said to Officer Castillo, that would likely not be admissible.
Okay. 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 Okay.
I think the next witness is Deputy Meredith from the Weld County Jail.
Mr. Donison, then I would like an offer of proof as to what Deputy Meredith would be testifying to.
Well, I guess Deputy Meredith, I was going to call as a witness to some of the phone call content that he had privy to. But I guess that's probably going to be called into question as well.
What phone call content are you trying to request from
Well,
Mr. Meredith?
Well, he's, when I spoke to him, he had said he listens to quite a bit of my phone calls. I know he's, I'm assuming I asked him to bring phone calls and I thought that I could get those in, but I'm assuming those are probably going to be objected to because they're phone calls that I asked specifically for on the subpoena. And I don't know how that works as far as that goes. I don't know if they have to bring the ones that we asked for specifically. We need to have those.
Is it in there?
On the paper.
No, all of Mr. Donison's jail calls should be discovered.
I'm sorry, Mr. Skelton, I needed to talk in the microphone for that.
Yes, I believe almost all, if not all, of the defendant's jail calls have been pulled by investigator Fick and sent over in discovery. And so if there's a specific call, the defendant shouldn't need to rely upon Deputy Meredith to pull it and bring it. He has access to it through the electronic discovery provided to him. If there's a specific call he's seeking to introduce, I guess we would need to know what that call is before I can make any additional informed objection to.
Thank you. So, Mr. Skelton, I'm just going to interrupt because it is in the subpoena. Specifically, Mr. Donison is indicated 2 phone calls from the Weld County Jail made by him to Mr. Benefit on May 3rd, and then one on May 4th of 2026.
We have access to those. Does that have to leave?
I guess we'll go listen to those over the lunch hour. I don't know if it makes sense to try to listen to them right now.
I can put the parties on notice. My concern is whether or not these are inadmissible hearsay. I mean, this is a call between Mr. Donison and Mr. Benefit.
I mean, at this point, I could kind of explain, I can clarify what I was trying to get out of them. We can kind of cut to the chase, I guess. I was more, and, we can kind of just cut to the chase, and I guess, we can kind of give Mr. Skelton the chance to object or not. I could just kind of, we can kind of save the court some time. It was more along the lines of Mr. Benefit. He just kind of started just reminiscing about some of the things that Ms. Quinlan had done. They were just bad acts. So I think they're going to be objected to be honest. There were some bad acts that she had done. So, I mean, they're probably going to be objected to be honest. There were some things he had remembered, some violent acts that she had committed against him. So I think there's some things that they're probably going to be objected to.
The people an opportunity to hear them.
Okay.
And then make a further record if they choose to do so.
And they were unprompted, there were kind of some things that he had just started
Mr.
remembering.
Donison?
Okay, I'm sorry. I apologize.
And we can provide, what we'll do is I think we can provide transcripts of those calls for the record as well. I think that probably will be helpful. And then we can,
Okay, thank you. If I could have parties then back at like
Cool with that.
1:15 so we can address it.
And then you are just the reminder that,
You have a 2 o'clock. It's my understanding you guys have.
sorry,
Is that an 11?
yeah, Judge Kearns.
They said it's 3:30.
Oh, it's at 3:30?
Yeah.
I had it at 2. Okay. Oh, it is at 3:30, sorry.
Okay,
I found it wrong, so we could just
that's,
take a break at that
I
point?
think that'll be around when we take an afternoon recess anyways. I think that makes sense.
Yeah.
So we'll try to make sure that you have the ability to do that.
Okay, thank you.
Um,
I'm glad you said something. Thank you.
Thank you. And then, you know what? The court needs to address a bond hearing on an F1. Mr. Skelton, I believe, is going to be handled by Mr. Perea. And we're just trying to figure out what time that will be.
Tony can't do it tomorrow.
Sorry, I'm just trying to give you
Can't do it tomorrow. Tony can't, or we.
they're going to have him appear virtually from the jail. They bringing him in person. All right. If I could have parties back at 1:15, I will let the parties know if I need to take a break in the afternoon to address that case with Mr. Perea.
Okay.
All right, thank you. Court will be in recess. Be seated.
I'll be here. Okay, that'd be cool. Yeah, appreciate it.
All right. Thank you. May be seated. Sorry. All right, good afternoon. Which of you have been selected as the foreperson? Okay. And has the jury reached a verdict? Can you please hand the verdict forms to the bailiff? All right, dispensing with the captions, the verdicts read as follows. Jury verdict, count 1, assault in the second degree, serious bodily injury. We, the jury, find the defendant, Christopher Donison, guilty of assault in the second degree, serious bodily injury. Jury verdict, count 2, menacing. We, the jury, find the defendant, Christopher Donison, guilty of menacing. Jury verdict, count 2, menacing. Verdict question. Did the prosecution prove beyond a reasonable doubt that the menacing was committed by the use of a firearm, knife, or bludgeon, or by the use of a simulated firearm, knife, or bludgeon? The foreperson has marked the box yes. Jury verdict, count 3, third degree assault. We, the jury, find the defendant, Christopher Donison, guilty of third degree assault. Jury verdict, count 4, false imprisonment. We, the jury, find the defendant, Christopher Donison, guilty of false imprisonment. Jury verdict, count 5, child abuse. We, the jury, find the defendant, Christopher Donison, guilty of child abuse. Jury verdict, count 6, assault in the second degree, restrict breathing. We, the jury, find the defendant, Christopher Donison, guilty of assault in the second degree, restrict breathing. Members of the jury, is this your verdict? So say each and every one of you. Okay. Mr. Skelton, do you wish to have the jury pulled?
no.
Mr. Donison, do you wish to have the jury pulled?
No.
The judgments of guilty will be entered and the matter will be continued for sentencing. Members of the jury, you have now completed your duties as jurors in this case and are discharged with the thanks of the court. The question may arise whether you may discuss this case with the lawyers, the defendant, or any other persons. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for the others to discuss the case with you, and you may talk with them, but you need not. If you talk to them, you may tell them as much or as little as you would like about your deliberations or the facts that influenced your decision. If any person persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it to me. I wish to add some of my own comments. Jury duty is something many people do not look forward to, and many people try to seek to avoid. After serving, I do find that most people who have served on the jury have found it to be an interesting and educational experience. I hope you found your experience to both be interesting and enlightening, and that your time served here was not overly burdensome. With that, you are discharged. I am going to have you return to the jury deliberation room. I do have some certificates of appreciation for you, and if you wouldn't mind waiting, I'd like an opportunity to come back and thank each and every one of you personally. Thank you. All right, all rise for the jury. Thank you, may be seated. All right, we are outside the presence of the jury. Again, the judgments of guilty are entered. Court will set this matter over for sentencing. I'll just note for the record, and I didn't mention it before, but Ms. Quinlan is present in the courtroom for the reading of the verdict for the people who are in compliance with VRA. I am going to order a pre-sentence investigation, including a domestic violence evaluation. Other requests for any of other evaluations or screens?
I think we'll need a ComCore screen as well.
Thank you. We'll order a community correction screen. For Weld County, Mr. Donison, are you requesting any other counties be screened for community corrections?
Am I even eligible for that?
Depends. Are you connected to any other counties here in the area?
Adams County or anything like that would be fine.
So I need to make a definitive order for that. Is there a connection that you have to Adams County?
Or Denver, my grandfather's out there.
Okay, we'll order Denver County. Denver won't do it. Okay.
Oh, Denver won't do it?
No.
Will Adam, here is fine.
Okay. We'll order one for here if, I'm happy to order one for Adams County if that's at least closer for your.
It is.
Okay. I'll order Adams County as well.
I appreciate that.
All right, we'll set this over for sentencing. Will an hour be sufficient for a sentencing hearing?
I think so, yeah.
All right, we also have 24 CR 157. Was that trailing this case?
And Your Honor, I think we could set that for a status with the sentencing. I'm going to have to talk with Ms. Quinlan, but I anticipate dismissing that case.
Okay, thank you. We can set these matters for September 21st at 10:30. Does that work for the people?
When is it?
It's about
10:30. Is the 21st at 10:30? Is that right? September.
Your Honor, Mr. Donison indicated that he would like me here for sentencing. I have a PTRC at 11. I
Can you
don't
just
know.
pull the microphone closer?
So, Mr. Donison indicated he would like me here present for sentencing. I have a PTRC at 11 o'clock that day. I don't know if the trial will go or not, but I don't want to schedule over it.
No, I appreciate that. Thank you, Mr. Lemus. Let me see if we can give you a different date. I'm sorry? September 22nd at 10:30? Just the next day?
Okay.
Okay.
What time was that?
At 10:30?
I can do that.
I think that works for the people as well.
Again, September 22nd at 10:30. Is there anything else we need to address on Mr. Donison's matters at this time? Oh, my apologies. The court does need to make a finding with regard to domestic violence. My apologies, I just kind of forgot. The court is finding that the people have proven the domestic violence factual basis beyond a reasonable doubt. Right. And then I know that Mr. Donison is currently in custody. However, given the guilty verdict at this time, I don't believe I think it's academic, but I don't believe he's entitled to bond at this time.
I think based on there being class 4 felonies, I don't know if he's statutorily prohibited from bond. I think the court can hold him in its discretion without bond. I agree. I think it's academic where he hasn't never posted bond. I don't know if he's statutorily prohibited from bond.
Sorry, I'm just looking up. Under 164201.5,